Away we go. So tonight's two things. One, I'm going to talk about a case from NCAT, which is this one, Aziz and My Property Inspections, and that's all about the importance of photos and exclusions in a pre-purchase report. And I think you guys are having a bit of a roundtable discussion about photos in expert reports after this. So that's all good. Hopefully, what I say will inform it. And then a little bonus episode. The Supreme Court has issued a practice note about the use of AI in the Supreme Court. Of course, most of it's directed at lawyers, but there is also a specific section on experts using AI. So I'll just give you the heads up about that at the end of this presentation. So Aziz and My Property Inspection. So what was this thing about? Probably a pretty familiar scenario to most of you. The punters were purchasing a property. The property was in Warren Road, Wood Park. The tribunal member, I think, must live in the eastern suburbs or something, because he said the tribunal was unfamiliar with the suburb, though Mr. Aziz said that Wood Park was a suburb near Greystanes. The tribunal was familiar with that general area. Anyway, the punters, Mr. Aziz, sorry, not Mr. Aziz, the people who had bought the property, did an internet search to find the inspector in the cooling off period. Usual story. They want the pre-purchase inspection done before they have to make a decision as to whether to proceed with the contract or not. 5 business days. So under pressure, as I say, the Azizes, if that's the plural, hadn't used a pre-purchase inspector before. They went on the internet, found this guy of My Property Inspections. His fee, in case you're interested, was $595. He went along and on the 4th of November did his inspection, reported no major issues, didn't note any cracks, thought the property was in standard or average condition for a property of its age. The homeowners thought the property was about, when they were buying it, they thought it was about 20 to 25 years old. In fact, it was about 40 years old. And then, given they had a relatively clean bill of health, they went ahead and bought the property, and not long after they moved in, on the 21st of December, as reported by them, they noticed that there had been cracks, and they hadn't seen any cracks when they inspected the property. But usual story, they said, well, we weren't looking particularly closely. We were more interested in the yard, etc., and we were relying on the inspector about that. When they saw these cracks and thought that their inspection report was a dud, they got a building inspection report from Jim's Building Inspections. That was in March, so a few months later. The Jim's report, by contrast, and he had photographs in his report, it showed extensive cracking that appeared to be the subject of some remedial patching. And he thought that the property was only in fair condition. Again, going back to our friend, the member, about this cracking and patching, he said, the tribunal remarked the patchwork appeared to be recent, somewhat vulgar in appearance and very noticeable. So he had some views. Anyway, in summary, the report said that the floors aren't level, there's a dip in the kitchen, same thing, there's a crack in the tiles in the bathroom, and the stormwater drainage is not connected. One of the homeowners managed to access the subfloor area, and he looked at the piers and he thought that they were somewhat irregular, and some being higher than others, and linked that to the cracking. So what did the inspector say in response to this? Well, his case was, firstly, his report noted that the inspection and the report were limited to the Australian standard. And that meant that all he was reporting on, really, apart from major defects that he saw, was the overall condition of the building, which he thought as it compared to similarly constructed and reasonably maintained buildings of approximately the same age, remembering it was 40 to 45 years old, and he thought it was average. There were some cracks, but they appeared to be very fine, and certainly weren't anything like the vulgar cracks that were shown in the photographs in the Jim's report. And crucially, in the MPI report, the photographs supported that observation. And he hadn't inspected the underfloor area because of access issues, and the Australian standard says if you can't get access, then you don't have to inspect. So the member, weighing all this up, came to the conclusion that, well, he didn't believe that the cracks, which were so evident in the Jim's report, were there when the MPI report was done. And he noted that the applicants didn't raise any concerns. They didn't say, oh, well, we've noticed some cracks, so you make sure you look at them when you're doing your report. He had his photos as evidenced by the photos. Any cracks were very fine blemishes, nothing like the Jim's report vulgar cracks. So all in all, the evidence didn't support a finding that when the MPI guy did his inspection in early November, there were any cracks that were evident and reportable in accordance with the Australian standards. The member was therefore satisfied that he applied the Australian standard, which is all he had to do when he prepared the pre-purchase inspection report. The intent of the inspection was to give an overview about the general condition of the building, which excluded inaccessible areas. Maybe if he had access to the subfloor area, he would have seen the piers, if indeed they were uneven. And I note here that the Jim's guy didn't get into the subfloor either. So we're just going on the say-so of one of the applicant. Anyway, our guy said, I didn't go there, so anything that's there is not covered by my report. You're relying on your own. And I should also mention that in the judgment, the tribunal member, as I mentioned before, he said that the Jim's report photographs contain what appeared to be cracks that have been very poorly repaired, vulgar repairs, he said. But the Jim's report didn't make any reference to remediation of the cracks. I think, reading between the lines, he thought that, in fact, the owners had, maybe the cracks had opened up later, the owners had tried to plaster over them and hadn't done a very good job. So ultimately, the member held in favour of the inspector and gave judgment for him. The punters lost, and that was the end of it. Now, obviously, I think the takeaways are pretty obvious. Photos are critical. You need to date stamp them to show that exactly when they were taken, because if later something different to what you have inspected is reported by somebody else, then you've got that photographic record that is basically incontrovertible as to what you saw. Of course, you can always have issues around, well, you didn't photograph this, or it was in the wrong light, or whatever, but so I say a comprehensive photographic record is important. I would suggest that you take more photos than you actually include in your report. Include in your report the ones that are most important. But if you've then got a bank of other photos that you can use, if someone says, oh, well, you didn't take a photo of that part of the stairs or that part of the ceiling or whatever, you can say, well, yes, I did, and here they are, and they don't show any blemishes. So photos are critical, and the date stamp is obviously critical. And limit what you're doing, limit your scope of work. I'm doing a pre-purchase inspection report in accordance with the Australian standard. Don't go outside that. If you are going to go outside that, make sure you've got your instructions in writing, and make sure that it's recorded in your report that you're only doing more than that as an exception, and exactly confine what you're doing that's outside the Australian standard. But you're opening yourself up to trouble if you go outside the Australian standard in your pre-purchase report, particularly given that, again, usually under some time pressure to get it done. So that's the case of Aziz and my property inspections. Now, I said we had a bonus episode here. The Supreme Court last week issued Practice Note General 23 on the use of generative artificial intelligence. So I'm just going to very briefly talk about this. It's relevant for the people who do expert reports. So it doesn't start until the 3rd of February, so we've got a bit of time to get used to it. And essentially what the practice note says is if you're preparing an affidavit or a witness statement or an expert report, you can't use generative AI. It's supposed to be your opinion, your words, not somebody else's words. If you prepare an expert report between now and the 3rd of February and you use AI, you've got to identify what parts of the report have used AI. And just to be clear, we're not talking about word processing software, which in itself is a form of AI. I mean, correcting a spelling is a form of AI, but we're talking about generative AI. And that's a form of artificial intelligence that creates new content based on information that it's got from elsewhere. So, for example, ChatGPT. What ChatGPT does is it uses a chatbot that asks you a question. Or prompts you to ask a question. You ask the question, and then it answers using information it's scraped from publicly available information on other websites and so on. So I guess to be specific, what we might be talking about here is you might say to ChatGPT or whatever generative AI you're using, summarise for me the Australian standard in relation to the height of rises and the length of goings in a staircase in a residential property. And ChatGPT will spit something out that conveniently and very quickly gives you that summary, which you could cut and paste into your report. You do need to be, if you are doing it, you need to, well, apart from complying with the new practice note, you need to be very careful because, and they've even given it a name now, artificial intelligence can come up with what they call hallucinations, which is a polite way of saying it just makes things up. Again, to give you an example, I have used ChatGPT or attempted to use it to do a bit of research. And so I said, give me what are the 6 latest cases in New South Wales in relation to a particular topic. It very quickly spat out 6 cases, citations, the whole bit. Either I checked those cases, either they didn't exist or they did exist, but they were on a completely different topic. So it just lied, basically. So that was using the free version. Apparently, if you subscribe and you pay, it's more accurate. But that's the kind of, as I say, the phrase is hallucination that it turns up with. So you need to be very careful with it. And if you're doing something in the Supreme Court, know that this will flow through to the other courts. You've got to declare that you're using AI if you're using it at all. And you probably shouldn't. So, questions?
Yeah, David,